Hello, everyone, and welcome to Uncivil Law. And for today, we're going to discuss a topic of sensitivity. We're going to discuss the ultimate punishment that's being meted out by the federal courts, the cessation of someone's life as a result of doing bad things. I'm trying to avoid using keywords at this point, so that's why I'm phrasing it this way. But the United States federal government recently started enacting the cessation of life as a result of doing bad things for the first time in 17 years. In July, they did it in 3 such cases where they cessated someone's life. And in order to get that far, you first had to get to some court cases. So there was a case dealing with the protocol that was used and what protocol was valid or invalid. So this case comes from the United States Court of Appeals for the District of Columbia, which was one of the last barriers to this happening. This is from April. And the case is entitled In Re Federal Bureau of Prisons Execution Protocol Cases. I think I'm far enough into the case that I can now mention bad words. So yes, what is the protocol that is to be used when you're executing this final judgment? What does the law allow for? Let's get started with this. On 3 different occasions, Congress has addressed the manner of implementing capital penalties for federal capital offenses. In the Crimes Act of 1790, the first Congress, very much the first Congress, specified the manner of inflicting the punishment of capital punishment shall be by hanging the person convicted by the neck until dead. This provision governed federal executions for 140 years, so that was the first such act. In 1937, Congress changed this rule to make the manner of the federal capital punishment follow that of state law. Quoting the relevant provision from the 1937 law, if the laws of the state with which the sentence are imposed make no provision for the infliction, so in other words, if the state doesn't have this penalty, then the court shall designate some other state in which the sentence shall be done in the manner prescribed by the laws thereof. So the federal government thought of that and said, oh, if you're in a state which has capital punishment, then you're just to follow whatever method they have. If you're in a state that doesn't, then just pick a state. Any state will be fine and do what they do. So the federal government thought about that. So there you go. Follow the default rule, and if there's no default rule, then just, I guess, literally pick your poison. Congress repealed the provision noted above in 1984, but left intact the underlying capital offenses. Accordingly, federal law still authorized the death penalty, but no federal statute specified how it be carried out. So the Congress repealed the section dealing with how it's to be implemented and didn't replace it, but they left intact the penalties. So they just didn't say how to go about doing it. So there's still capital punishment, but no law specifying how to do it. So presumably that makes it an administrative matter now, because that's how you normally fill in these gaps. We all know how that works, right? So yeah. So let's go make some regulation, because that's normally how we deal that. When Congress doesn't speak, the administrative state will. To fill the gap, the Attorney General promulgated a 1993 regulation entitled Implementation of Capital Sentences in Federal Cases. It provides that unless a court orders otherwise, the method shall be by the intravenous injection of a lethal substance or substances in a quantity sufficient to cause death, such substance or substances to be determined by the Federal Bureau of Prisons. So, yeah, we are now doing this by regulation, which is not ideal, but Congress can't be bothered. So it's like, okay, administrative state, you figure it out. So the Attorney General says, fine, I'll pass a regulation. The regulation says we're going to do intravenous injection by chemical or chemicals in such amount as may be determined by the Bureau of Prisons. So that's how we're going to do that. Fine. Congress then enacted the Federal Death Penalty Act in 1994. Under the Federal Death Penalty Act, as under the 1937 statute, the manner of implementing the federal death sentence turned on state law. So Congress then reenacted and say, okay, just do what the state law provides. All right, that's what Congress said. The Federal Death Penalty Act also provided that a marshal, which is the officials that do this for the federal government. The marshals are the ones that execute federal orders of all kinds, or federal court orders more precisely. So it provides that the marshal overseeing an execution may use an appropriate state or local facility. So it doesn't necessarily have to be in a federal prison. You can use a state facility if you like, and may use the services of an appropriate state or local official. So, you know, if you don't have facilities in your federal prison, not to worry. If the state or local official is willing to do it in their prison, you can transfer them. So if the state will be execute it for you, you can transfer it to state prison to get it done. So that's also an option. At various times since 2001, the Department of Justice has developed protocols setting forth the precise details for carrying out these sentences. One such protocol was adopted in 2004 and was updated in 2019. For 3 federal executions conducted between 2001 and 2003, the Bureau of Prisons used a combination of 3 substances. So this was the famous 3-drug cocktail, which the federal government used and pretty much all the states used, to the best of my knowledge, until very, very recently. Sodium phenol, a barbiturate that induces a deep coma-like unconsciousness when given in amounts, pensodium bromide, which stops breathing, and potassium chloride, which induces cardiac arrest. So this was the 3-drug cocktail. In 2008, the Bureau memorialized this use of its 3 substances. In addition, it is as an addendum to its 2004 protocol. So this was what they were using, and they formalized it. But then here's where things changed. In 2011, a practical obstacle to using sodium phenol had emerged as an anti-death penalty advocates pressured pharmaceutical companies to refuse supplying the drugs. So, yeah, this was a problem. The pharmaceutical companies were not giving the drugs as part of the 3-drug cocktail. So they weren't able to get the substances that they needed anymore. So now the federal government has a problem. How do you go about and actually execute these judgments without the protocol? So what do you do? So one of the things you could do is revise your protocol. So that's the next thing they tried. The Bureau of Prisons explored the possibility of using other substances. The Bureau's personnel visited state sites and evaluated their protocols, which is not a bad idea, looking to what's being done in the field. The Bureau of Prisons also consulted with medical experts, reviewed assessments of difficult executions, and studied relevant judicial decisions. It considered several options, including 3-drug protocols using other barbiturates, 3-drug protocols using different weaker sedatives, and a 1-drug protocol. So they're considering different options. After an extensive study, the Bureau of Prisons recommended the use of a single barbiturate, phenobarbital, carried out to federal executions. It noted that many recent state executions had used phenobarbital without difficulty, and the courts repeatedly have upheld the constitutionality of its use. Further, the Bureau of Prisons found a viable source for obtaining it. So this is the 1-drug cocktail that is now used, which I don't know if you can really call it a cocktail since it only has 1. But anyways, it's the 1-drug cocktail, phenobarbital. So it is a painkiller. So it's similar, I guess, in that way to morphine. So it's a painkiller, and like morphine, if you give enough of it to someone, they will die. So yeah, you just use a painkiller and you give enough of it to cause a lethal reaction. So yeah, this is the method that is now being used pretty much universally, is phenobarbital as a 1-drug remedy. So that is what they're trying to do. But of course, someone wanted to sue because they didn't want to be executed. So they're suing and saying, oh, this procedure is invalid. So let's discuss more. For the reasons noted above, the inavailability of drugs, the Bureau proposed a 2-page addendum to its main protocol. The United States Marshal Service concurred in the protocol. On July 24, 2019, the Attorney General approved the addendum and directed the Bureau of Prisons to adopt it. The Bureau of Prisons did so. This 2019 addendum makes phenobarbital the sole lethal substance to be used in federal regulations. This appeal arises from several consolidated cases, which is why we have the in re name, because it's consolidated, in which 12 death row inmates challenged the federal execution protocol. So they say, oh, this is an invalid protocol under the relevant law and relevant regulations. Okay, let's give that a try. On July the 25th, 2019, the Department of Justice informed the District Court that it had adopted the revised protocol providing for the use of phenobarbital. That same day, the Department of Justice set execution dates for 4 of the people that are involved in this appeal. Each of them moved for a preliminary injunction. On November the 20th, 2019, the District Court issued the preliminary injunction, prohibiting the government from executing 84 plaintiffs. So the District Court said, yes, I'll issue the injunction. The court held that the plaintiffs were likely to succeed on the merits, that the 2019 protocol exceeded the statutory authority, because under the relevant statute, they went back to the old rule, which said you're supposed to follow the state rules, which may not be the same thing as what the federal government is doing. In particular, the court ruled that the Federal Death Penalty Act gives decision-making authority regarding the implementation of the sentences to the state, which does seem to be somewhat implied by the language. Thus, insofar as the 2019 creates a single implementation, it is not authorized by law. So they are going to a pretty decent statutory argument. Congress has said what the method is. The method should be the same one as adopted by states. In states that have lethal induction, this is the method that's more or less used, but it's not universal. And so, to the extent that you're adopting a universal protocol, that may be in violation of the relevant federal statute, which by its own terms attempts to track what they're doing on the state level. So is that a valid argument or not? The government filed an interlocutory appeal, filed an appeal while the case was ongoing, and moved this court to immediately state or vacate the injunction. Without addressing the merits of it, we conclude the motion did not meet the stringent requirement for stay pending appeal. So we said, no, we're not going to stay that, but we'll consider your appeal. The government applied to the Supreme Court for an emergency stay or vacator of the preliminary injunction. So the Court of Appeals said, no, we're not going to stay the injunction. We're not going to vacate the injunction. We'll hear your appeal. And then the government said, but we really want you to vacate. So they tried to go to the U.S. Supreme Court, which is the next step. The Supreme Court denied the application of the stay, but directed the Court of Appeals to decide it with appropriate dispatch. So the Court of Appeals said, no, we're not going to consider your stay, and we'll consider it in the ordinary course of us doing business. And the Supreme Court said, we're not going to issue the stay either, but we are directing the Court of Appeals to expedite this. You can't dilly-dally around. You can't just put it on your docket and delay this and put it in some sort of queue or whatever. So basically saying, give this a priority treatment. You have to consider this right away. So now we're going to consider it right away. So now the Court of Appeals is hearing the appeal. They didn't issue the stay, but now they have to hear the appeal. So now they actually have to decide whether or not this protocol is good. So let's go on. A preliminary injunction, which is what you're seeking an injunction, is an extraordinary remedy that may only be awarded upon a clear showing the plaintiff is entitled to relief. So, as is always true, an injunction is considered equitable remedy. It's not, technically speaking, legal, although no one cares about the distinction except lawyers, and even us don't really care about it anymore. But anyways, yeah, it's an equitable remedy. So basically, it is extraordinary. It is not a common remedy. To get an injunction or a temporary restraining order or any of that stuff, you have to show something exceptional. Then there's a multi-part test. So let's see if this test is satisfied. A party seeking an injunction must establish that they're likely to succeed on the merits, that they're likely to suffer irreparable harm in the absence of the relief, the balance of equity is tips in their favor, and an injunction is in the public interest. That is the 4-part test for injunctions. You have to show those 4 things. That is the 4-part test for all injunctions basically everywhere. You have to show those 4 stuff. On appeal, we review the district court's legal conclusions from scratch and the weighing of the 4 relevant factors for abuse of discretion. So we are going to do the legal issues, from square one, and how you weigh those factors based on discretion. For several reasons, we exercise our discretion to resolve the merits of the claim. So the Court of Appeals doesn't necessarily have to resolve the merits of it. They could resolve the legal issues, right? They could say, here are the legal issues, and then send it back to the district court to actually decide the merits based on that legal issue. That's the norm. But where the facts are established, there's nothing preventing the Court of Appeals from doing it. It's just that it's not normal. So the Court of Appeals is pointing out, look, we know what the facts are. The facts aren't in dispute. So we have all the information. The trial court decides the facts. So we're not trying to decide facts. We're just trying to apply facts. Now, normally we wouldn't do that, but we're going to do it here. Why? This claim is purely legal, which the parties have briefed thoroughly. It's been well briefed, right? It's just a legal issue. At oral argument, the parties agree that we should decide now. So both parties say, yeah, we should decide this right away. Finally, assessing only the likelihood of success would invite further litigation. So if we only addressed one of the merits of it, it would invite litigation on the other things. So let's just decide the whole thing. And the Supreme Court did tell us to decide this with appropriate dispatch. So let's just decide the whole thing and avoid this, this piecemeal thing. Okay, so having decided that we need to consider the whole thing and decide whether or not this applies, how do the 4 factors apply to this situation? As explained in separate opinions that follow, Judge Katsas and Judge Rowe, which is 2 people, and that's what you need in a panel decision, both reject the claims on the merits. So 2 judges say no, which is what you need. Judge Katsas concludes that the Federal Death Penalty Act regulates only the top-line choice among execution methods, such as the choice to use lethal injection instead of hanging or electrocution. Judge Rowe concludes the FDPA also requires the federal government to follow execution procedures set forth in state statutes and regulations, but not the procedures set forth in less formal state education protocols. Judge Rowe further concludes that the federal protocol allows the federal government to depart from its procedures as necessary to conform to state statutes and regulations. On either view, the plaintiff's preliminary claim is without the merit. Okay, so that was a lot of language that said a whole lot of things. So the first thing that you have to decide is exactly what does it mean when the Federal Death Penalty Act says you're to follow the state procedures? What exactly does that mean? That you're to follow what the state does. And two judges, which is what you need, says all that means is you are confined by the top line choice. The top line choice being the ultimate method of execution, whether that's lethal injection or some other method that a state can prescribe. So all you are constrained about is that choice, but you're not constrained by the specific way the state chooses to implement that. You can do it that way, but you don't have to do it that way. So the statute as written, according to two judges, which is again what you need, says, yeah, you have to do what the state wants to do in terms of the ultimate method, but you don't have to follow the state-specific procedure. So to the extent that you are in states that have lethal injection, which I believe is every single state at this point that has the death penalty. I believe other states have other options that are in reserve. So I believe, I could be mistaken, there might be one state out there that only still allows for the electric chair, but I'd have to double check. But I think every single state, maybe except one, has lethal injection as an option for the states that have the death penalty. So basically they're saying that, well, because you're confined by that choice, you then have to do that, but you can do any method along those lines that you like. Okay, fair enough. The government also asks us to decide whether the protocol it adopted via the addendum violated the notice and comment procedures of the Administrative Procedure Act. So, yes, the federal government can do this, but did you do it the right way? Did you do it through the process set forth by the federal government for adopting stuff? The district court did not reach that issue, and the plaintiffs urge us not to reach it because that would be another lawsuit that we could fight over. But again, that's a legal issue. And so we can decide it. We don't have to, but we can. But we have been ordered to do it with dispatch. So we have all the facts we need, so we can decide this. Judge Katsas and Judge Rowe, again, that's 2 votes, that's what you need, resolved that the notice and comment claim, because on their view, it involves a purely legal question intertwined with the merits, so we can decide this. On the merits, therefore, Judge Katsas and Judge Rowe conclude the 2019 protocol and addendum are rules of agency organization, procedure, or practice that are exempt from APA requirements for notice and comment rulemaking. Judgment for the government must be entered on this claim. Okay, so the APA in the broadest possible sense, to explain what this means, the APA does not apply to internal stuff within the agency. So it doesn't apply to how the agency is organized in terms of like its staffing or what, whether its internal bureaucracy or its mechanism should be. It doesn't apply to that. It doesn't apply to its internal procedures. It doesn't apply to its internal practices. So essentially, the APA does not apply to internally focused stuff. The APA only applies to externally stuff. It only applies to stuff that applies to people outside the agency. All right. So then there might be a question here as to which of these 2 categories we're in. Are we inside the agency or are we outside the agency? Now, 2 judges say, well, for the purposes of this exercise at least, we are inside the agency. Yes, these are technically impacting people that are not part of the agency. Yes, that's true. But 2 judges say this is an internal practice, internal procedure, internal policy. Yeah, it's just an internal policy. The fact that, it's impacting people, we're kind of look past that point. So yeah, 2 people say this is just an internal thing, and therefore the notice and comment procedures of the APA are not required. Whether or not that's a legally correct decision is debatable at best, because again, in general, the APA, when it applies externally, you do have to follow notice and comment. Presumably this is external in nature, but 2 judges of the relevant court of appeals disagree with me. So, okay, well, that's the law, I suppose. The court vacates the preliminary injunction and remands this case for district court for further proceedings consistent with the opinion, which would ultimately result in 3 people's execution last month in July. For the reasons given in the separate opinion, Judge Tattel dissents. So that is the end of our coverage from In Re Federal Bureau of Prisons execution protocol cases before the United States Court of Appeals for the District of Columbia Circuit. In this case, we learned that the federal law requires the federal government to follow the ultimate process that is set out for in the relevant state law, which I believe in every state, maybe with one exception, is lethal injection. But it doesn't require them to follow the specific protocol adopted by the state. They can, but they don't have to. So the federal court rules that the federal government adopted a perfectly fine procedure. They also rule, perhaps somewhat controversially, that this is essentially an internal process, even though it affects people outside the scope of the agency. These are not employees of the agency, most decidedly. But even though I guess the idea is because it impacts only one person or one person at a time, that it's close enough. But in any case, that's the law because 2 circuit judges say it is. And there have been executions actually occurred based on this. So yeah, I guess that's the law. So we've learned a lot about how death penalty is carried out, at least on the federal level. There is a one drug policy that now exists, and that is the method of execution as far as the federal government is concerned. And at least for the moment, that's the end of the coverage of this case. Thank you so much for being part of the Uncivil Law family. I appreciate your continued support. If you haven't already done so, please subscribe to this channel, and you can also support us financially by clicking the applaud button below. Thank you so much for your contributions to our channel. It helps our work grow. Until later, cheers and goodbye.